If you've been served with a lawsuit, you may want to talk to a lawyer about what to do. A lawyer can tell you what the person who has sued you is asking for and can give you advice about what you can do.
If you think there is some legal reason that the case should not be heard in the place where the petitioner filed it, or if you think the case should not be heard at all, go quickly to a lawyer and get legal advice about your case before you sign or file any papers. You must protect some rights in special ways or you lose them. If the petitioner made a mistake, you might not be able to object to the mistake after you filed a response to the lawsuit. If you are representing yourself as a respondent, you have some choices. One thing you can do is file a waiver of citation with the clerk's office. This form says that the person who signs it has gotten a copy of the filed petition and is giving up the right to get official notice by issuance and service of citation. The form sometimes says that the person gives up the right to know anything more about the lawsuit. If you want to make sure that you keep the right to get notice about each court hearing and take part in the case, then file an answer to the lawsuit instead. If you want to take part in the case, file an answer to the lawsuit with the clerk's office. An answer is sometimes called an original answer or a general denial. There is no fee to file an answer. Send a copy of the answer you file to the person who signed the lawsuit against you and keep a copy for yourself. After you file your answer, the petitioner must send you written notice of the date and time of any court hearings in the case and give you a copy of any papers that he or she has filed in the case. If the respondent receives legal notice but does not file an answer or response and does not ever come to a hearing in the case, then the petitioner can try to get a default judgment. A default judgment means the petitioner wins without any contest from the respondent. Getting a default judgment can be hard because it requires extra paperwork. To get more information on how to get a default judgment or on what to do if someone gets a default judgment against you, click on the button that says Default Judgment Information. An answer usually has a general denial. This is a statement asking the court to make the petitioner prove every part of his or her case. The answer may also have specific defenses to some of those claims.
The answer by itself does not make claims against the petitioner. If you want to make your own claims against the petitioner or plaintiff and have the court award you something, you must file a counter petition.
While there is no fee to file an answer, there will be a filing fee if you file a counterclaim, unless you file an affidavit of indigency and the judge says you don't have to pay. You can find forms for different kinds of answers and possible defenses in a law library, a public library, or on Texas Law Help. Whether you file an answer, a counterclaim, or any other paper in your case, you have to give a copy of each paper to every party in the case. This is called service. To serve papers such as an answer after the case is filed, send them by certified mail, by fax, or by hand delivery. If you hand deliver the papers, get a receipt so that you can prove that the person got them. If the party is represented by a lawyer, serve the lawyer. If the party does not have a lawyer, serve the party.
The next video will address getting information about court procedure and the rules that you will have to follow in court.